Against the backdrop of the public breakup of Trump and Musk, no matter how that gets resolved or not, we have two new decisions by the United States Supreme Court alt-right majority that support DOGE, the Department of Government Efficiency, against the American people and their privacy interests. I'm going to put it all together, synthesize those two things against the backdrop of the fight, public spat between Trump and Musk, and tell you what it means. Two cases came out. We're now getting daily 2, 3, 4 decisions dropped, opinions dropped by the United States Supreme Court as they try to wrap up their work by the end of June. And they sequence how they're going to drop their opinions. It's up to them which opinions drop in the public on which days. So 2 days ago, we had 4 different decisions that happened to be 9-0, with the Supreme Court all ruling together to show some sort of unanimity, some sort of kumbaya moment. That was sequenced by Chief Justice Roberts. And now we've got back-to-back rulings on DOGE. There are a dozen cases out there related to Elon Musk and DOGE. I've done a hot take already about what I think a final breakup between Donald Trump and Musk means for those cases if he ends up testifying as the ultimate insider whistleblower against Donald Trump, a guy that in the last 48 hours, he's called for his impeachment. But this is about the substance of 2 of the cases up at the Supreme Court. One of them has to do with a Maryland court's order that ended up at the 4th Circuit Court of Appeals about DOGE getting access to your and my Social Security Administration records. So let's call it the Social Security case. It's also known as the Social Security Administration and the American Federation of State and County Municipal Workers, AFSCME. Okay, so you got the Social Security case and a 6-3 ruling allowing DOGE and therefore Donald Trump to gain access to your and my personal private data, disability data, medical data, financial data, all the things covered by the Privacy Act from 1974 that have now just been thrown into the wood chipper by the Supreme Court with a dissent by a impassioned dissent by Ketanji Brown Jackson, joined by Sotomayor and Kagan on the same day. Because why not? They also issued another decision in a case called U.S. DOGE Services versus Crew, in which they found that a lower court judge was wrong to determine that automatically that U.S. DOGE service was subject to public records requests, and wants the judge to do it over again with new instructions to also be mindful to give deference to the executive branch, because God forbid we don't give enough deference to the president and their unitary theory of government when you're on the Supreme Court, that they're giving instructions to the lower court judge to go back to the drawing board and try to figure out through discovery, respecting privilege related to executive branch communications, whether this DOGE thing is subject to Freedom of Information Act requests. I mean, when you put the 2 rulings together, how is DOGE not subject to Freedom of Information Act requests? But that's the type of inconsistencies, the type of incongruities we're seeing at the United States Supreme Court. Let's start with the Social Security Administration case. Now, both these cases, and that's one of the major problems called out by Ketanji Brown Jackson, is they came up through the shadow docket, meaning scant record below, no real proceedings at the lower level other than injunction proceedings, an incomplete record, an incomplete briefing. So there's only 2 briefs, not the normal 3. No oral argument, no times for deliberation. It's just emergency application, because that is the approach of the Trump administration. They figured out the loophole to press and pressure the Supreme Court by stampeding them into decisions in their favor that fall along ideological continuum. If it's the right wing versus the moderate and the left wing, and the moderates and the left wing are outnumbered 6-3. And that's how Trump is hoping, through a combination of ferocity and velocity, that they're going to come up with a win at the Supreme Court. They're batting about 500. With these 2 wins, they're actually slightly above that now, probably winning about 65 to 70% of their cases at the United States Supreme Court. They're losing at the lower court level by like 96%, even with Trump judges in the 70%. But at the Supreme Court, where it matters for most of these major policy decisions, they are winning more than they are losing. In the Social Security Administration case, all we get is a decision that they're going to apply the stay factors while the appeal is still going on, but they're going to side with the Trump administration to allow them to get the access to the documents while the Fourth Circuit continues with its appeal on a normal course. So 6 months or a year from now, maybe there's a case that comes back to the United States Supreme Court. And if it does, they'll deal with it. But in the meantime, the milk is spilt. Cow is out of the barn. The DOGE, whoever's running that these days, and it's not Amy Gleason, I assure you, and certainly it's not Elon Musk. It's probably somebody along the lines of Russ Vought, who runs the Office of Management and Budget for Donald Trump and is the author of Project 2025. He now has access to your and my privacy data because the Supreme Court just gave it to him 6-3. Now, what we have is a repeat, effectively, from a decision just last week in which Ketanji Brown Jackson wrote almost the exact same dissent about why are we in an emergency? This is not an emergency because the Trump administration doesn't want to wait like every other litigant is required to do to go through the normal course. That does not make an emergency. What is the emergency that they have to get to the bottom of Social Security in the meantime? Ketanji Brown Jackson then goes through in her dissent, joined by Justice Sotomayor. She had one imagery that I loved. It's on page 3 of her dissent. She said, once again, this court, meaning the 6-3, the 6 majority, dons its emergency responder gear like they're firefighters, rushes to the scene and uses its equitable power, the stay issue, to fan the flames rather than extinguish them, making it worse, not better. It's a very powerful amount of imagery there that she's written. She then goes on to talk about the Privacy Act of 1974 and the safeguards put around our personal data and why Congress did it. Because of all the employment, insurance, medical, and credit data that is inside of the Social Security Administration and the limits on that. The record, she says on page 5, evidences that DOGE received far broader data access than the Social Security Administration customarily affords for fraud, waste, and abuse reviews. In other words, she questions why they need so much access and why can't it be anonymized? Why can't it be anonymous? Why does it have to be like they know it's my file? Why does DOGE and some 20-year-old tech bro hired by Elon Musk, no longer in the government, why does that have to happen? She then goes on page 6 to say, just last week, I wrote about the requirements for granting a stay application, because that's what all this was about. But it's about the merits, even though it looks like it's a procedural win for Donald Trump. He gets exactly what he wants. He gets the documents, the information. You're my private data for the duration, for the next year or two, and probably permanently. And that is the problem. She's calling out, Ketanji Brown Jackson, that the stay factors have not been met, especially when they already asked the entirety, the en banc panel of the Fourth Circuit for a stay, and it was rejected 9-6. That means something in the world of a factor analysis. And it's another good reason why the stay should not be granted. She says, with today's decision, it seems as if the court has truly lost its moorings. It interferes with the lower court's informed and equitable assessment of how the data is best accessed through this litigation, and it does so without any showing by the government that it will actually suffer concrete or irreparable harm from having to comply. She's basically saying the court is bending over backwards to benefit one party, the executive branch, and that's it. She says that she ends her analysis this way. Page 9. To accept this line of argument sends a troubling message that this court will allow departures from our stated legal standards and the basic norms of our judicial system, such as respect for lower court rulings and equal justice under the law for certain litigants. What she means is for the executive branch and Donald Trump. It says, in essence, that although other stay applicants must point to more than the annoyance of compliance, the government can approach the courtroom bar with nothing more than that and obtain relief from this court. Nevertheless, it is startling to think that this court is allowing that. She says on the bottom of page 10, the court opts instead to relieve the government of the standard obligation, jettisoning careful judicial decision-making and creating grave privacy risks for millions of Americans in the process. Now, that's the first case that dropped. The second case that dropped on the order list on Friday as well, and I'm going to post both these things in Legal AF Substack, has to do with another court's decision that DOGE effectively is a federal agency, therefore subject to Freedom of Information Act public record disclosure, where you and I, and in this case another group, Freedom of Information Act Foundation, can get documents, and crew can get documents from that agency, right? Remember the transparency that Donald Trump always talks about? Well, what the court say about that? Some of the reporting was Supreme Court rejects finding that DOGE is a federal agency for Freedom of Information Act requests. That's not true. What happened here is a little more technical. What happened is they didn't like the way the judge below made the decision about whether DOGE was subject to Freedom of Information Act requests, about its ability to compel and to obtain information. They believe the factors require more than that. Here's what they say. And they sent it back to the trial court level to fix this problem, then have it come back if necessary. He says that the court says 6-3 again, with the same 3 in dissent. The portions of the district court's April 15 discovery order that require the government to disclose the content of intra-executive branch, inside the executive branch, DOGE recommendations, and whether those recommendations were followed are not appropriately tailored. And any inquiry into whether an entity is an agency for FOIA requests cannot turn on the entity's ability to persuade. Rather, separation of powers concerns counsel judicial deference and restraint in the context of discovery regarding these things. Of course, let's give all the deference to the executive branch, and so that we can't control them and we can't supervise them or give any judicial intervention whatsoever. So that is the DOGE rulings. What does it mean for the lower court cases? There are other cases. There's a major case, I'll leave you on this, in front of Judge Chutkan, who used to preside over Donald Trump's criminal cases, in which she's trying to get to the bottom of whether there was an improper appointment under the appointments clause of the Constitution of Elon Musk to head DOGE, therefore making everything that DOGE did invalid, and she will overturn it. That's still going on. These cases don't impact that, except what we are seeing when you pull these two cases together is 6-3. Including Roberts, including Amy Coney Barrett, and where their heads are at, bending over backwards to support a unitary executive branch theory and the power of the presidency over almost everything else, and siding with him related to DOGE over all the other litigants. And that's a problem, because there's going to be a lot more DOGE cases, including that Chutkan one, coming up. You're on Legal AF. Hit the free subscribe button. Help us continue to grow. These two orders I just read from, I'm also going to post on Legal AF Substack, along with some commentary there. So until my next report, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event, by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states, and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok firm, fighting for your justice every step of the way.